Mr. McLeod,
Contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court taken into custody.
Really? That's it.
This court hearing spirals into disorder almost immediately. Mr. McLeod is facing a serious charge for allegedly assaulting a police officer, but instead of addressing the accusation, he insists the court has no authority over him. He relies on well-known sovereign citizen arguments, interrupting repeatedly and using legal phrases that have no real standing. Each time, the judge firmly but calmly corrects him. As the tension builds, the situation becomes increasingly heated, and by the end of the hearing, the judge determines there is no choice but to have Mr. McLeod spend the night in jail. The entire exchange is frustrating, yet oddly compelling to watch, as his confidence steadily collapses under real courtroom procedure.
Understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay.
I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here.
What stands out right away is the judge's patience. Despite constant interruptions and confusing statements, the judge repeatedly gives Mr. McLeod opportunities to respond properly. It's remarkable how composed the judge remains while explaining basic legal principles that Mr. McLeod claims not to understand. You can tell the court is trying to be fair, even as the hearing drifts further off track.
Okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on a couple things, or I'm going to be in trouble. Okay. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney withdrew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend, to observe. They've participated. I'm removing them from the hearing.
At one point, a brief reaction from someone in the courtroom captures the mood perfectly. It's an unfiltered moment that reflects what many people in the room are likely thinking. Even the judge seems to pause before moving forward. Moments like this help explain why Mr. McLeod's attorney previously withdrew from the case. Mr. McLeod continues flipping through a stack of papers, searching for a rule or argument he believes will suddenly end the case in his favor. He appears convinced he has found a loophole, while everyone else already understands how this will end.
One second. Okay, so in enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I challenge subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
doesn't
jurisdiction.
exist under the Constitution.
Your objection is noted. All right, so, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on.
As the hearing continues, it becomes clear that the judge has reached the limit of what can be tolerated. Without raising his voice or showing frustration, the judge directly explains that none of Mr. McLeod's claims apply. The contrast is striking. One side calmly rely on established law, the other clinging to unsupported ideas. This moment highlights why judges hold authority in the courtroom. They rely on facts and procedure, not personal theories.
I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod says I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Your Honor, I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
McLeod,
statutes.
I have other matters. Mr. McLeod,
Involved agency. What's that?
you know, I understand you want to object to things and you're going to be allowed to object to things. Okay.
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws. I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying it enough to where I can comprehend it, as you say.
you comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal
There's
it.
no
to the
such
Michigan
thing as
Court
a
of Appeals.
statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question or I'm going to hold you summarily in contempt. And the court officer will bring you to a jail cell and we'll talk about it tomorrow. You understand that?
So
Mr.
in
McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine.
I don't understand the charges. All right,
Mr.
I don't
McLeod is in
accept the
contempt of
charges.
court, taken into custody.
Really? That's it. Protecting my rights is what you said last time. This isn't true. You guys are following
Follow
unlawful
unconstitutional
orders. You're following
orders.
unlawful orders. It's not
Not a
constitutional
good
at all.
thing.
Mr. McLeod's in contempt, he's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
What makes the situation more troubling is that Mr. McLeod could have accepted legal representation. The court even reminds him that he has a right to an attorney, including a public defender if needed. Instead, he chooses to represent himself, relying on arguments that courts have rejected for decades. Early on, the judge patiently explains how the process works. But even the most understanding judge can only allow so much disruption. The charge itself is serious. Assaulting a police officer is often treated as a felony. And in this case, Mr. McLeod appears to be facing the possibility of several years in prison. Rather than addressing the accusation directly, negotiating, or presenting a defense, he spends a hearing repeating claims that hold no legal weight. The result is more time wasted and another night in custody. There is also a sobering side to this. Sovereign citizen arguments have been dismissed by courts since at least the 1990s, and judges are required to follow established law, not individual interpretations. Continuing down this path only increases the risk of severe consequences, including long-term loss of rights and extended incarceration. That wraps up this breakdown. Let me know your thoughts in the comments. Do you think Mr. McLeod truly believed these arguments, or is he trying to avoid responsibility? If you enjoyed this type of courtroom analysis, don't forget to like and subscribe. Thanks for watching and take care.